Card for a parking problem.
423.
Yeah, that's where we're gonna 28 on truck when you're ready.
Go ahead.
The one truck, White Lincoln X-ray 985 should come back up next.
So you had 2000. Patrick Spalding.
10-4. If you can just throw them lower than something like that, I might not be leaving a note on a vehicle if I can verify it.
Rockingham 505. 505 and 50 Hillism case for Athens. Complainant, soon to be ex, slashed her tires and has made threatening comments to her. She's concerned he might return.
Yeah, forgive this at 32.
10-4. You're assigned to a vandalism case in Athens. Did you copy the 505?
Yeah, 4. Look at that. No, 3 and Depot Street. Trucks away entering left.
7435.
Down.
10-4.
You go 643 again.
143.
You go with that 43 you had. I didn't hear any, but I had jump and flag me down.
10-4. I just wanted to know if you should be put back 76 to Cavada Circle or to the subject's address.
Yeah, I'll be 23 back on that town property case, and I'll be 76 to the Williams Road address to see if I can find the alert.
10-4. 449 1120. 449 1121. Thank you. 10-4.
Code 4. 4.
Currently at 535.
Yeah, that was a great coach.
535.
Should be. Got no endorsement inflicted about out. I'll flight up that way.
Caller is now able to close the front door. He's now pounding on the door, trying to get it still. He's about 5 foot, long dark hair, got tie-dye shirt on, and number 21 is on.
Switch is on, here comes the throttle. Chevy breakers in.
We have separation. Inboard and outboard, they're on. Coming forward with the side sheet. I've got a blowout. Vapor 3. Pitch to 0. Pitches out. I can't hold altitude. Correction. Elbow is off. Flight emergency. Flight call. I can't hold it. She's breaking up. She's breaking.
Hey guys, good to see you. You're gonna have to bear with me just a little style-wise because I've set up a new camera. That other camera on my laptop had this feature that auto dimmed the background, and so it always looked like I was sitting in a cave. So I just set up my camcorder, but it's aside the monitor. So I'm gonna have to retrain myself. Like right now, I want to look at the screen, the monitor. This is me looking at the monitor. That's what my instinct is to do, especially if I'm talking to someone else. But even when I'm on the screen, I kind of look at myself. It's just like it's a natural human instinct to face the person you're talking to, even if it's yourself. So I have to train myself to look at the mirror until I can figure out some better way to do this. I have a laptop here it's an older laptop that the camera is connected to, but the screen on it is dead. So I have it connected to a large monitor on the side. So this is a little bit of a challenge for me to get used to. I'm sure I'll figure it out. And then to look over at chat, I have to look all the way over here. And I also, this camera, even though it's set further back, I felt like, I don't know if it was because I'm not used to doing it on the monitor. I looked too big. So I sat back as far as I can. So now I can barely reach the keyboard. So I'm watching chat, but it's going to be an adjustment, and I'll probably have to figure out something in the future to maybe set up another monitor, smaller monitor right in front of the camera so I can see it. But this is my introductory day of trying to do this, and then I'll have to work through that tomorrow. Actually, I'm doing a show tomorrow night with Kate too, and we're going to recap the trial so far. So that's going to be really good. Tomorrow morning, I'm going on the John DePietro show. It's a big radio show down in Rhode Island. I am not familiar with Rhode Island that much. I hadn't been to Rhode Island in many, many years. So, but I guess this is a really good show. And so we're going to talk about the case for about 15 minutes. So that'll be pretty cool. But we fortunately have a day off from court. So I think there was a juror that requested that. So thank you for that, juror. It's great to have this day off. I'm looking over at chat now again, so you'll see me looking away. It's just going to be really hard to stop it. I am going to have to set up a different monitor here because I want to be able to see chat, So maybe today you'll have to just kind of bear with me, kind of looking at you sometimes and sometimes looking at chat. Karen did TV production for a few years, hoping we can help with the setup. Okay, yeah. I mean, it's the modern technology enables us to do at home what Karen did professionally with all kinds of really good equipment, So I need to just really get some kind of monitor. I see this monitor is too big, so the camera it's a big screen TV, so the camera is beside it. So I'm looking at the camera right now, but it's really, really awkward for me. I'm just not used to it. So we'll figure out a way. Grant has court. Oh man, yeah, that sucks. That situation there. I mean, I'm sure a bunch of nonsense that'll go away, but it's a pain in the ass to deal with it. Now, I want to deal with. Someone said, I got to roll back and chat and see who it was. I don't remember who it was, but is it Gator Man? I think it was Gator. Wanted me to address Granny Juju. Hi, Juju. This Gator wanted me to address the group chat, the group text between Matt McCabe, Chris Albert, and Brian Albert. How do I say this? I really am baffled that people find this to be troubling. So I want to be respectful to the people that think that, including Gatorade. How do I approach this? Let's do it this way. One thing that I really encourage everybody to do in all things in life when you're trying to think about things is to try to see things from multiple angles instead of just trying to see things from the angle that fits the thing that you already, the narrative you've already bought into. That's that confirmation bias. That's what it is you already believe in something, and then everything else you see, rather than trying to look at it from multiple angles, you interpret it in the way that already fits your angle. So you don't make any effort to try to see it from the other angle, because this is a classic example. All right. Chris Albert was not at 34 Fairview that night. Now, even if you don't believe that, even though you believe all the witnesses are lying about that, try to see it from a different angle. Since no evidence shows Chris was in the house, try to, and even if you don't believe it, try to weigh it out from all the different possibilities. Okay. So let's, just for hypothetical reasons, okay, Gatorman, Gatorade, Gatorman, go with the idea that Chris Albert was not in the house. He went home just as he testified. And it seems likely the feds would have found otherwise because they got everybody's data, right? So I think it's pretty a sure thing that Chris Albert did not go to 34 that night. He lived in walking distance from where they were drinking downtown. So he walked home. So he wasn't there at the after hours party. And over the next couple of days, people are asking him what's going on, and apparently including somebody from WBZ. And so part of this group text, he asked Matt McCabe, what do I say? And Matt just says, say what, he never came in the house. Now, there's nothing unusual about that because John never went in the house. Now, even if you don't believe that, just at least try it out from that angle before you decide that this is something suspicious here. If it was true, if it was true that John never went inside the house, now play that angle out, okay? If it was true, then isn't that what Matt would say? That John just never came in the house? Isn't that what he would say? So, and then isn't it natural that Brian, because this was a group chat, would just say, exactly? So I don't see anything suspicious at all about that chat exchange. Either it's a completely normal chat exchange about what happened that night, or it's them trying to get their story together, right? So if you believe in the conspiracy, okay, then I can see, don't dismiss any possibility, right? And try to consider all the possibilities. So on the one hand, you have the possibility that it's just these guys trying to get their story together, and on the other hand, you have that it's just Matt telling Chris that John never came in the house. So what evidence do you take from that? Well, I guess you take nothing, if you're just looking at that one piece of evidence, then none of us should take anything, right? Either way is plausible, right? So that's when you look at all of the other evidence. But what happens here is the people on the Free Karen Reed side take something like that, and especially the way David Yannetti spun it, and maybe they lack the people that are listening to that lack the critical thinking skills to ask the questions from the other side. What is the other side? Especially since Lally came right back on redirect and made it clear. But people weren't listening because they already had this. That's what confirmation bias is. You already have this thing in your head, and everything that comes out. In fact, I remember I see, and there were a couple of Free Karen Reed people here in chat when that happened, and they typed boom. They typed that in the chat. And I'm sure all over all the other grifter chats that were covering this that night at that time, I'm sure there were 1,000 booms, people typing boom. I don't get it. I just don't really get it. I mean, it frustrates me. I don't want to, maybe depresses is too strong, but it gets me down to think that so many of my fellow citizens lack basic critical thinking skills that they couldn't say, was that just a normal text exchange? That they're seizing on every little piece of word and going, aha. I don't understand that. That really, it bothers me. It worries me. And people doing that are the basis for this persecution of people that are innocent. I don't know. Like I said, it bothers me, and I don't really know what to do about it. You hope to get people to develop better critical thinking skills. And look, I'm no rocket scientist. I can't fix a car. Um, my brother-in-law had to put in a simple railing at my parents' house this weekend. I couldn't do that. He's got to use a stud finder, figure out where the electrical wiring is too. God, you wouldn't want me doing that. Trust me. So I'm no rocket scientist. This is not rocket science, though. This is just really simple logic. And it's a lot of times it's just making an effort to see things from both sides. That's it. So every little piece of information you get, you should try to see it from both sides and then step back and look at the larger picture and blend it in with all the other evidence you're getting. But if you're unsure about what happened, and as probably most people are at this point and should be, because the trial is not even close to done and we haven't even seen so much of the evidence yet, then if you're just covering it objectively, like a juror, like you hope that a juror would, right? Then just try to look at each individual piece of evidence from both sides. Okay, look, and the jury can do this because they've seen the position from the state and from the defense from the start. So the state has said Karen struck John with her SUV and left the scene of the accident. And the defense came right out and said, no, my client was framed. John was ambushed and he was really killed inside the house. Now, they haven't come out and said that yet, but they've obviously strongly implied it. And by the end of the trial, they'll be certainly saying it quite clearly. So the jury understands what the two theories are here. And they should be sitting back and just objectively looking at everything. Sorry, I'm glancing over at chat again. It's very, because I want to see what you guys are saying. I'm used to watching what you guys are saying. I say even Eldon is here. I mean, if Eldon's here, I gotta pay attention to chat because chances are he's going to say something entertaining sooner or later. Frank Perry, thank you. Let's see. I even had to figure out where to go to reach to get my. It's so sad how these law tubers, some of them who know Jackson, seem to be latching on to the defense for clicks and views. Yeah, it is sad, and I want to actually talk about that with Kevin Mahoney in a little bit. I'm talking to other lawyers on the side, including a friend of my college, best friend in college and roommate who's a judge. And these people are just quietly baffled at this conspiracy theory. But yet there are a lot of lawyers. Some of them might be ambulance chasers like Melanie Little or something, but there's people that are on YouTube trying to grift on this, trying to build a following. Is there no ethics anymore? It does seem like maybe we get a distorted sense of things because of social media and because of the YouTube world, but it does feel like there's now a lack of ethics now. I don't know. It's very troubling. So there was a big article that came out today in Boston Magazine. Again, I keep glancing. See how I can't stop glancing away? There was a big article in Boston Magazine about Turtle Boy. I've read it on my phone in the car. I only had a chance to read about half of it. I'm told I need to finish it because the excellent reporter Gretchen Voss is quoted in it. So I will go back and finish it. I didn't really want to finish it, not only the length of it, but it was getting a little frustrating to me because, again, there's this false idea of what Turtle Boy is. If Turtle Boy was what they want to present him as, I'd be in support. I mean, they're making it seem like Turtle Boy is controversial just because of his loud methods. They make it seem like he's a guy that's after the truth and wants to get the truth out there, but he's controversial because he has these loud and obnoxious and entertaining methods and is willing to scream at people and blah, blah, blah. That it's a style thing. The problem with Turtle Boy is style. That's what they're trying to sell us on, right? No, listen, I didn't follow Turtle Boy before last April 18th when that first story came out on Karen Reed. I had heard of him. but I'd never seen him and I'd never been to his website. Okay. I like the idea of alternative media. I do not trust the legacy media. And see, if somebody donates, it comes up in color. So I do actually see it now. But normally I try to watch all the chat. But this is, I'm going to have to get another setup here, but I want to put up Lavish donated. Thank you, Lavish. Appreciate it. Aiden, my understanding, the expectation is he will go to prison. Let me see if I missed any other. And also Latin Rican. I love Hispanics and I love Hispanic food. But I love Hispanics. They're always so passionate. The ones I've known a lot. There's another group called Karen Reed Trial Not Free Karen Reed. This approach has made me see the case in a different way. Oh yeah, I just joined that group today. So thank you for bringing that up. I don't know if Natalie's involved with administering that group or she just invited me to it, and some other people did too. But in fact, I have it open right now in case people have questions. They can put their questions there or they can try to put them in chat. And I will try to get them to Kevin when he comes on. And so I appreciate that. We all have, Kevin is he's a very thoughtful guy, a very experienced lawyer who will be able to answer a lot of our questions on this. And, there's endless questions. So we'll get to as many as we can. So anyways, Turtle Boy. The idea that this guy is a truth teller who just happens to be obnoxious. Let me tell you a personal experience with Turtle Boy. Some of you know that have been following this channel for a while. Let's see how many people are here right now. So there's a large enough audience that there are a lot of new people here. Last summer, I was following this case. I started out thinking there might be a conspiracy. The 227 search for how long to die in the cold, if that was true, if that was true, there definitely was a conspiracy. But we now know that it probably was not. To me, certainly was not. But if you're just looking at this objectively, it's in dispute. If you're looking at it in a neutral kind of way, if you haven't studied it as long as I have. But last summer, we didn't know that. And so I was on the fence, just trying to explore things. I knew that Turtle Boy had been given, I could tell just from reading the article, I didn't know this from any inside information, but that Turtle Boy's opening article had an entire defense theory intact given to him that he went with. So you know that you're listening to a defense theory. Now, just automatically, if you have any common sense about the world, you should be skeptical. Okay, because that doesn't mean the theory wasn't true. It just means you should start out that you're only hearing one side of the story. It's kind of like you're a principal at a high school and two kids get in a fight. You got to hear both sides of the story, right? Why would you just assume that one side of the story is going to be true? And so you can tell it was coming from the defense. So my position all summer was just asking questions, because there were things about this conspiracy theory that were intriguing. Why didn't the Alberts wake up? Or the Chief Berkowitz finding a piece of taillight glass 6 days later. There was a lot of little things. Were those dog wounds on John's arm? And obviously 227. Did the data show that John went inside the house? All of those things were intriguing. But the other side of the equation was, is it really likely that 11 people inside that house, including people's moms and wives and kids, they're all going to keep quiet for this conspiracy theory? Is it likely that a Boston cop is going to kill someone and then drop that person on their own lawn, or drop them on their own lawn, clinging to life in order to die? That's all super unlikely stuff. And so you should have been on the fence. And anybody hearing about this theory for the first time should be on the fence. You should be asking those kind of questions. as to whether or not it's true. Now, I was doing that, just asking those kinds of questions calmly, not yelling at anybody. And everybody on my team last summer, and my team had grown, believed in free Karen Read. So it was an awkward spot for me, but I didn't find the conspiracy theory convincing. So I kept asking questions. Well, and my channel was small. Here I was getting, on a good day, 100 views, maybe 125 views. A lot of days it was way less than that. So, and his Turtle Boy getting 3,000 views, 4,000 views on every show. So why would Turtle Boy give a shit what I said? Well, I'll tell you why, because no one else was saying it. So that's what became a threat. The only other person asking questions about this was Kate Peter, and no one did more to get to the truth than Kate Peter. No one knows more about this case, the fundamental evidence of this case, than Kate Peter. That's just a fact. But she was not doing a lot of shows. And there was a perception that, right or wrong, that her interest in this case was more related to Turtle Boy because she had been feuding with Turtle Boy for years. I didn't know Kate Peter. I never spoke to her back then. I wish I had. I wish I had reached out to her. I wish I even knew how to reach out to her, but I never did. And there was an episode, I think it was in late August, maybe early September, I think late August, where Turtle Boy showed up in my chat. I had Dave and Erin and guest Sean McDonough. So the four of us were on. And Turtle Boy showed up with his mob. And his mob was seething at me. They were growing more and more angry because I had been asking questions. How dare me, right? And he brought all those people in just to attack me. And what was his attack? This is the interesting part. Turtle Boy's attack on me was he accused me of both sidesism. And that's his way of saying, I don't want this guy asking questions. And I want to silence him. I either want him to step in line or shut up. And I'm going to threaten him with social media destruction if he doesn't toe the line. Because this is a strategy that Turtle Boy has found effective for years. They can control even mainstream media reporters, lawyers, police, because they are ruthless in their tactics. They won't just go after you. They'll go after your family. And so he was saying, get in line. No questions. No both sidesism. So this is not a guy that is just after the truth and has obnoxious ways of doing it. This is a guy that's not after the truth. This is not a guy that truly respects free speech because he wants to silence anyone who disagrees with him. And he'll use any methods possible, including smearing people with fiction. That's what he is. Now, I don't know if he was always that. I don't know if he became that over time, but that's what he is. He definitely operates entirely without any conscience at all. He has no regard for the truth. He knows the truth in this case. We know when he was. We know the day, the time, and the place that his lawyer told him the truth in October about Karen Read. We know his reaction. And I'm sure it was stunning because here he has been telling everybody for months, listen to Daddy. He wants everybody to call him Daddy. Don't question him. Just listen. But he knows the truth now, but he doesn't have the intellectual courage to tell his audience the truth. And in the meantime, a whole other cottage industry of grifters has arose. Or is it arisen? Tom, help me. I think it has arisen. I think it should be. Now, this is important. This is not me trying to start a social media war with another content creator. No. This is a phenomenon that is dangerous. It's become dangerous in this state. And I don't know how to stop it. And people have sent out to me, another lawyer sent out to me wondering if me and Kate were part of any effort to change things legislatively to address things like witness intimidation. And I said, I'm not. First of all, I don't have that I'm not a lawyer and I don't have any connections to legislator. And I don't know if Kate does. I'll ask her tomorrow. But, it's a problem for me because the thing is I don't see an easy solution. My solution has always been educate the public, get the public to ask questions, get them. To me, from my experience in life, the overwhelming majority of people are decent people and want to be decent people. They want to do the right thing. So if you get them to see this phenomena for what it is, they will eventually ignore it, tune it out. And many of those people will eventually find the courage to step up and do what they can. So that's always been my approach. I'm wary of giving the government more power because these things are really difficult to define. All Turtle Boy has to do is ask a question. He can say, hey, did so-and-so get a DU? A lawyer comes out and says something that he disagrees with about this case. And all Turtle Boy has to say, boy, did this lawyer get a DUI 10 years ago? Has he had shady clients? He can just put it in a question form, even if he's making it up, even if it's not true. But he has this massive following now of ruthless people like Jen Altman and this whole team of people around him that will dig dirt. If they find real dirt, they'll spread it. If they find something there's a kernel of truth and they can twist it into something else nefarious, they'll do that. But you can't prove that Turtle Boy ordered the code red because he's got a dog whistle and he goes out and asks a question or says something, and they step in line. So I don't really see an easy way to stop that phenomena because it's now what Turtle Boy has done over the last year in terms of intimidating the witnesses. Yeah, that's easy. He broke the law clearly on that stuff and he's going to go to jail for it. But he's also going to learn. And from now on, he's going to really just rely on the dog whistle and let his minions, basically like a godfather, right? That before the RICO statute, that was the way it was in organized crime. The godfather never had to even order anybody to get killed. He just kind of a nod and you could never prove it. So the godfather got paid, but the godfather didn't have to commit any crimes themselves. So it was without the RICO statute, it was very difficult to get to these people. Now, I'm not suggesting a RICO statute would apply in this situation here. I'm just saying it's going to be very, very difficult to stop this. Again, I'm turning away to look at chat and to thank people for the donations. So James, thank you. James said Yannetti should be disbarred, the lies, the Fed involvement, the intimidation. There are a lot of issues there, and we're going to talk about that with Kevin tonight. But, where does the boundary? There's a legal boundary and there is an ethical boundary. So what is that boundary? I don't know. Because Kevin is also an excellent defense lawyer. So he will probably have some answers to those questions, And I don't think they're easy questions that have easy answers either, to be honest. Because a defense lawyer is also duty bound to do the best he can to free his client, to put up a vigorous fight. But does that include smearing innocent people with this third-party culprit theory? I don't know. Chick from the Bricks, let's see. Thank you for the donation. Chick said, keep up the great work. Justice for John's family and everyone wrongfully accused. I mean, yes, this is why I know some people would say just cover the facts and don't say anything antagonistic or insulting to other people. But what I'm watching is a form of bullying. And that to me is the best word that describes it. There can be more sophisticated words. I'm not the most sophisticated guy. It's bullying. That's what a mob does. And that's what a mob does in the 6th grade when a bunch of kids get together, maybe behind a stronger kid, and they pick on the other kids, a couple of weak kids. They feel empowered by that. And I think that's an issue here too. I don't know how you stop it. Karen said journalism is supposed to present both sides. Exactly. What Aiden is doing is not journalism. And even, listen, there's just, nobody should be fooled. He never had an interest in truth in this case. Let me also say this too, before Kevin gets here. I want to always correct the mistakes that I make. I'm going to start with one here. So this is not even a mistake. I speculated on the center console that Lally asked the jury to pay attention to. And based on some information that I had, it seemed maybe there was an override button there. Now, maybe I don't know if there is or there isn't, and I don't know that particular model, but I would say now that, again, still speculating, it's more likely that Lally just wanted them to look. That's where the actual, that the screen for your reverse camera that shows when you put it in reverse, there's a monitor there that comes up. I think on that model, that's where the screen is. So it's probably going to be as simple as they want the jury to note that when Karen put it in reverse, that was working. And so she should have been able to see someone behind him. But that's a whole different thing to me. If she was hitting the override, if there is an override in that model, that's way more guilty, because that means you're doing it on purpose. And so, but at this time, I would say my best information is that's not the case. Other things I've got wrong, and I've corrected them over and over again. The big thing is I allowed it to be reported here this summer that there was a 911 call by John on Colin drug dealing in the neighborhood. That was bullshit. I've done whole videos on it. And someone had tried to be cautious. I knew the theory about Colin all summer last year. I never would say his name, and I wouldn't even, the few times I mentioned, I would say the nephew, but I never believed even that made sense to me, that this 17-year-old kid is going to beat up a Boston cop or attack a Boston cop. It just doesn't make sense to me. So, but on that one time, the source was Sean, and he claimed to have, there was a lot more to that story too. I'm trying to avoid saying it because there were things that I said I wouldn't say back then. So I'm trying to keep confidentiality, but it was all from Sean. And that smear on Sean. Now, where did that ultimately come from? We have to speculate a little bit. Another thing I got wrong was no true bill on the federal grand jury. That didn't turn out to be accurate. I reported that in October, maybe November. And then another thing I got wrong, and some of this was based on my understanding. I don't know if I actually had an actual report, but I believed that the Canton police had a car sitting there all day. And now it looks like very sloppy. They were gone. So when Julie Albert came over with the donuts at 8:30, there was no one there. So even though I think some of the things the police did on the scene, I think that the little thing they did with the leaf blower and documenting that turned out to be excellent work, because that saved evidence that would be gone now. Because you got an evidence, you could, by looking at that video, you can see where the blood was. You can even see what layer it was in the snow, get a sense of that. However, to be completely gone from that scene by 8:30 seems to me incredibly sloppy, because that street must have been plowed multiple times after that. There should have been a cruiser sitting there making sure that scene wasn't plowed. There should have been a cruiser sitting there all day until the state police arrived. And I don't know, what's important when it comes to accountability. I mean, in Roman times, they had all the roads, and along the roads were arches that would be built made out of stone. And the rule was the architect, guy who designed the arches, when they finally finished it and they had to remove the bottom piece to now the arch will stand, the architect had to be standing underneath it. And that was their way of saying he has to be accountable for that arch. And if it's going to fall, it's going to fall on his head. And so I looked at Lieutenant Gallagher, I think it was. I loved his testimony. I thought he made a lot of good decisions that day, and I thought he owned Alan Jackson. However, there needs to be accountability here. If he's the one that's responsible for that crime scene being abandoned by 8:30, he needs to be accountable. I don't know what accountable means, but he needs to be accountable. I'm not saying, I don't know what should happen there. I liked him. I thought he was brilliant. He seems like a great cop, but someone needs to be accountable. That was a horrible decision. Or maybe it was Chief Rafferty or Chief Berkowitz. Chief Berkowitz was at the time, and I think Rafferty, but he was out on medical leave, and I think Rafferty was acting chief then, and now she's chief. I don't know. Whoever made that decision to not secure that crime scene, they couldn't. The idea of securing it with police tape was never going to work because of the blizzard. However, there should have been a squad car sitting there, making sure the street wasn't plowed and make sure someone didn't go walking, trudging through the scene. I don't think they were worried about planting evidence, but still, you have to secure that. That's a scene that you know the state police are going to be coming in to search for evidence. You need to secure that scene until they get there. And if that means an officer has to sit in the squad car for several hours, well, isn't that what they do anyways most of the time? I'm not trying, I don't mean that in a disparaging way. I mean, but that's a big part of the job, especially during a blizzard. I remember some of my friends in Worcester, cops, said that if you ever want to rob a convenience store, do it during a blizzard, because the cops are all just kind of relaxing in their squad cars. Then, so do it during a snowstorm, they used to always say. Let me just take a sip of coffee. Kevin should be here by now. Hopefully he's not having a connectivity issue. Anyways, but if you're listening, Kev, take your time. It's no big deal. We got plenty to talk about. And let's go to another comment. Latin Rican said, "Don't worry, buddy. It won't be long before he calls someone else daddy." That's funny, and that is true. And Karen says, "Journalism equals present the facts. Slander equals crime." I mean, yeah, it's it's hard to know where the line is between a slander, which is a crime, or at least is something you can be sued for anyways, which is not the same as a crime, but at least you have a way of holding someone accountable. Again, sorry, I can't. You notice I keep looking away from the camera. It's very difficult to just look into that lens. Let me tell you. Oh, here's Kevin here. So hold on one second, guys. Hey, Kevin. I don't see you there. There's no one backstage at the moment. I hope it's not something different because I'm on a different computer, but let me open this on a different computer and see. Yeah, because you're not backstage in the one I'm looking at, but I did this. I got sick of that camera that I had. I don't understand why it wouldn't be there. Hold on 1 second. The wonders of technology. Yeah, I see you on the other screen. All right, I think. No, maybe not. No, actually, I don't see it. Let me just send you the link again. I don't know. Okay. All right, I apologize, guys. We're still working it out. Oh. As you guys know, me and Kevin are a couple of boomers, so it's sometimes we got to work things out. Is there an echo there now, Jeff? I think it should have stopped. It was probably only an echo because I had on the other computer. Higgins did not flip. So what are they going to, the thing is when Higgins testifies, what are they going to say? This is the problem with this conspiracy theory too, is that it seems like no matter what they say, that doesn't happen. The next, it's nobody holds it against him. Nobody learns. You go on Sean's channel, he's going to get 10,000 views. All right, Kevin is coming up. Hey, Kevin. All right. That did work that time. So let me bring you in.
Thank you for your patience, Kevin.
Oh, you did good that time. That was good. I don't know if you heard me earlier, but I have a new setup where I'm looking at an actual camera and then my monitor is the right. So I'm trying to balance between look at the camera, but my instinct is going to look at you because I'm talking to you. So if I act a little funny, it's because I'm kind of going back and forth on this, not used to it yet. All right. So let's get to, I've copied down some questions that other people have, but let's get to some of the ones that we know that you and I wanted to talk about. So what did you think of Judge Cannoni's evidentiary rulings? And this is something that we don't know. Most of us aren't lawyers here, so you'd be able to really help us a lot. So her refusal to allow the witnesses to, except in some of these instances, talk about conversations they've had.
I think that she's been pretty restrictive. So first of all, let's discuss what is hearsay. So hearsay is an out-of-court statement offered for the truth of the matter asserted. So let's go back to the conversation that the Brian Albert and his wife were going to testify to when Jen came into the bedroom and announced that John was dead. And there was an objection which Judge Cannoni sustained. The Commonwealth wasn't trying to prove through Jen's statement that Mr. O'Keefe was dead. So it wasn't being offered for the truth of the matter asserted. It was just simply being offered to demonstrate what the scene was like. Right. So that objection should have been overruled. And the same thing with other conversations. So if in a conversation somebody asks you, so where should we go next? That doesn't qualify as hearsay because it's not being offered to prove anything. Right. So
so what was the objection based on then, Kevin?
If you want me to say what I think, a lot of attorneys and a lot of judges, believe it or not, do not understand hearsay. They think hearsay is any statement that was made outside the court. Okay. That's what they think. And so when somebody's going to go into a conversation, a lot of attorneys just are going to object, even though it doesn't even really meet the criteria of hearsay.
Would it be possible in a situation like that? So I don't know what sports you follow, but everybody knows in sports about the makeup call, right? And so let's say you're an NBA referee. So sometimes you're trying to keep a little bit of balance in the game. Is it possible that Judge Cannoni is doing that a little bit here, or maybe even anticipating, looking ahead a little bit, knowing some testimony is coming, for instance, from John's nephew and niece? And so she may split the rulings here a little bit. Do they think like that at all, judges?
I don't think I've ever been the recipient of a makeup call. The other thing that we should understand about, even as the hearsay rule is usually applied or misapplied, any statements from the defendant are always coming in. Now, there's one exception to that. So let's say, for the sake of argument, that the defendant says something to the police where he says, "I didn't do it," and that's all he says. Then that statement's never coming in, because that's why people shouldn't talk to a police officer, because anything that you say that damages you is admissible, and anything that you say that is helpful to yourself may not be ever admitted in court.
Right. Well, can't the defense bring it in then?
No.
Okay. All right. So that's interesting. Yeah, we'll have to keep an eye on that then with the hearsay as this goes forward. I think people have a better understanding of it now. What about now the big testimony this week that's still ongoing was Matt McCabe and then Jen McCabe. Now Jen hasn't been crossed yet. That's going to be big Tuesday. So what did you draw from that?
I thought Mr. McCabe was, I thought he was an okay witness. I thought that the smiling and the sometimes the chuckling and sometimes the over friendliness, I don't think that he treated it with the seriousness with which he should have, and he didn't come across as well, I would hope. On the other hand, Jennifer McCabe was an all-star. She made extremely good eye contact with Mr. Lally. She, every now and then, if you saw, she was looking at the jurors and making good eye contact with the jurors, sometimes just telling the answer to the jurors, which is what I always recommend people do.
Mhm.
And I thought that she was measured. I thought she became emotional at the appropriate times. And
Mhm.
I just thought she was fantastic, except for one error,
Mhm.
which is when she testified that Karen Reed showed them the taillight when they arrived in Mr. O'Keefe's driveway.
Yeah.
And Mr. Lally turns around and introduces the video, which shows them going straight into the house.
Yeah, so that could end up being a problem. It really depends on if now that obviously the three of them came out of the house a few minutes later to get back in, this time into Carrie's car and go out to look for John. So we better hope that if that ring video was not deleted, or Jen better hope that it shows the three of them looking at the taillight. But without going into details, sneak preview, there will be other testimony from Jen herself. I'm sorry, from Karen herself, that should affirm that they did that. But yeah, I mean, it's interesting. So then it becomes something where Jen just misremembered exactly when Karen showed her that.
It
Right.
also, but it also tells us that Mr. Lally did not spend enough time with her
Yeah.
preparing her direct testimony. Because if there was that kind of a uh, memory lapse or mistake, that should have been worked out during the trial prep.
Hmm.
And so, and again, I want to defend Adam Lally. I know there's been a lot of criticism.
Hmm.
I have done a murder case that lasted almost 6 weeks. It's a tremendous amount of work. It is
Yeah.
difficult to keep on top of it, and I'm sure that he is overwhelmed. So
Yeah.
I do say that. I think that overall, my impression is he's doing a good job.
I think you bring up a really interesting point here that I kind of want to flesh out a little bit. So a lot of the witnesses, it's clear that they're not prepped, but isn't there a bonus in that too? If you over prepped them, it's going to feel like their stories are too much on the same page, or overly, the jury might sense that their stories are a little bit prepped. So is that part of the thinking here?
In other words, is Lally doing less preparation than perhaps might be hoped for because
On purpose. Yeah.
he wants them to come across as authentic?
Yeah. Yeah.
I mean, I don't think that explains it, because if I were the prosecutor, I would think any prosecutor would want to show the video to Miss McCabe so that she knew what she was going to be seeing while she was
Yeah.
testifying. So
Right.
again, I don't want to be too hard on him. He's probably working from 7 o'clock in the morning until midnight.
Right. Right. Because we saw this come up again with Colin, where I thought this was unusual, but you can tell us. But David Yannetti was really pressing Colin as to when he met with Lally and how long he met for and what Lally told him. I didn't even know that they would do that normally in a case, but it was interesting. Unless Colin was not telling the truth, Colin was like, "Yeah, I met with him last month for about 15 minutes." I think he said something like that.
Yes, I personally have not seen a defense attorney try that tactic. I find it very interesting. Uh, I think there's always an expectation that a prosecutor is going to meet with the witnesses. How would he not meet with the witnesses?
Yeah.
And then, if
Right.
as far as preparation, what is preparation but asking with the witness what he anticipates asking him, and hearing what the witness is going to tell him in return?
Right, and Yannetti was amazing. He wanted Colin to remember all that and recite it there in court. I thought the judge might put a stop to it, but I don't know what the law is on that, because it's like, is he going to remember an hour-long let's say he met with Lally for an hour or 6 hours, right? Because he was, he might be. Is he supposed to remember everything that Lally asked him? I thought it was a strange question to ask, to put on that kid.
It was an unusual question in my experience. And then with the follow up with Lally was asking him with regard to whether or not he had spoken to anyone. And
Yannetti.
I'm sorry.
I think it was Yannetti that I meant. It was my mistake. I said Lally, but I meant Yannetti. Yeah.
No, on redirect,
Okay.
Lally
Yeah.
asking Colin about instructions with regard to not talking to other witnesses, to explain his answer that he hadn't been speaking to witnesses.
Right.
And you could tell that Lally asked him a series of questions and Colin answered no. And I could tell that Lally anticipated the answer was going to be yes. In other words, I didn't speak to witnesses because you instructed me not to.
Right. Yeah. I remember that now that you say that. Yep. So let's see what else we got. What do you think overall about this defense strategy? And this is a huge question, right? There's so much we can go into here. This really goes back into the insights I got from you back in September and your really good article back then about how the credibility of the defense team is kind of fragile and you want to maintain it. So if you to me, it's risky to oversell something. You create this expectation, and then if you don't meet it, you've kind of damaged that credibility, right? But what do you think about their opening statement and their strategy overall? What do you think about that?
Well, with regard to credibility, the prosecutor starts off with a ton of credibility because he's not being paid to do this. I mean, he's being paid to be a prosecutor, but he's not being paid to prosecute this particular defendant.
Yeah.
When an attorney shows up, a defense attorney, you have to just presume you have no credibility with the jury. In fact, you probably have a credibility deficit. So you've got to build that credibility up with the jury, because if the jury doesn't trust you, then all the questions you ask are immaterial. All the arguments you make are gonna be dismissed if you don't have credibility. As far as the defense and their credibility and their overall strategy, I don't quite always follow what they're trying to accomplish. In particular regard to David Yanetti's opening statement. So it wasn't in a narrative form. He didn't take you from point A to point B and discuss, for example, Karen Reed dropped him off at this point and she walk across the yard and enter the house. Or he didn't mention that they had a fight and that, John stormed off. Nothing. He didn't go into any of those details. What he did was he focused almost exclusively on the claim that she was being framed. And
go ahead. Yeah.
No, go ahead.
No, please finish, because I was just going to continue on that thought. But go ahead.
So I found it interesting that they put so much of the focus on the alleged frame job, but didn't try to say, maybe put into context, for example, why Karen Reed left so many nasty voicemails. Like what prompted her to leave those nasty voicemails, and to try to explain her actions afterwards. For example, she went by the O'Keefe residence, she grabbed some belongings. Apparently she sat in on the children when the brother was telling the children that John had died, and then she left, and then she made these other statements to people suggesting that they would never see her again.
Yeah.
He didn't attempt to address any of those issues in his opening statement. He didn't provide any reason why we, as the jurors, why they would want to question the integrity or the memories of the paramedics. He didn't address a lot of what I would have expected him to address, and so I assume that the strategic consideration here was we don't want the jury thinking about the actual facts. We want them only thinking about the conspiracy.
Now, some of this was right. Now, some of this was because the judge didn't allow him to use the third-party culprit. She ruled that they were going to have to develop that during the trial from evidence. So that probably limited what they could do on the specific narrative of what happened there, right?
No, because because under that narrative, Karen doesn't know what happened to him. Right. In other words, she drives the car to the 34 Fairview, etc. He could have gone into all of that without violating Judge Cannoni's third-party culprit ruling. That said, with regard to the third-party culprit ruling, I mean, he went right up to the line, if not crossed it, with that opening statement.
Yeah, he went up to the line. Yeah.
I'm sure that that was discussed at sidebar following his opening.
Yeah. Yeah, but and there's nothing. It's not like it's football. You can't throw a 15-yard penalty, right? So it's all about walking up to that line. Do you do that a lot in your strategy? You walk up as far as you can, and then all she can do is push you back. But that's it. You've already got it in, right?
Well, this is a rather unique experience because how long did it take them to pick a jury? A couple of weeks?
Yeah. Yeah. No, much less than that. I think it was maybe like 4 days, actually. Yeah.
It was only 4 days it took them to pick a jury?
Yeah.
Really?
Yeah. They got it much quicker. Maybe 5, but they got it much quicker. Yeah.
But here's the thing. All the apparatus is in place. The jury's finally been selected. The jurors have been vetted. Certain jurors have gotten out. Other jurors have been already replaced. Everything's ready to go. She's not going to declare a mistrial because of happening. She's going to admonish him. She's going to give a curative instruction, as she did, that the opening statements are not evidence, and that's how she's going to try to diffuse it.
Okay. Interesting. Yeah, that's true. Yeah.
And then remember something: the Commonwealth doesn't have a right of appeal.
Right. Right. Double jeopardy.
Correct.
So what about Karen's relationship with her lawyers? And have you ever had a client like that?
I had a client once, maybe, I don't know, 20 years ago. And in order to keep him from doing anything ill-advised, shall we say, I asked him if who his favorite artist was. I believe he told me Bruce Springsteen. And I told him to spend the entire trial writing the lyrics to every Bruce Springsteen song.
That's awesome. So you've considered a distraction. Like what Karen is doing in court, she's like right there, part of the legal team. You would consider that a distraction?
I would consider, with my clients, explain to them that if the client is talking in my ear while the witness is testifying, I'm probably not going to hear either one of them.
Right.
So if the client wants to communicate something, I always ask the client to write it on a notepad. I give them a notepad. Please just put the notes in front of me. I'll read it as soon as I get an opportunity. She seems to be kind of in Alan Jackson's ear frequently. And that can only detract from his ability to like think strategically about what he wants to do next in the trial and to consider the things people have just testified to on the stand. I would think she would be involved. And from some of the videos that have come out where she seems to be extremely agitated, I would think that is going to be, especially over the course of weeks, that's going to be exhausting for Yannetti and Jackson to deal with. Exhausting.
Yeah, I guess there was an incident last week in court off camera, but with the jury still there, where she really let Alan Jackson have it. I even like kind of grabbed him or something like that. But in that small courtroom, everybody sees it, and the jury definitely saw it. So I don't.
The jury was still in the room?
Yes, that's my understanding from
Really?
2 sources. Yeah.
That I have tried 2 cases in that courtroom. That courtroom is really small. That's a really small courtroom, and that sort of like if it had been done in the bigger courtroom, which was the original plan, it gives some room for the emotions to sort of diffuse. But in that small courtroom, it's almost like it amplifies everything.
And the jury's really watching the defendant, right? Her every move to kind of try to get a sense of things. I would think is that what your experience is?
They always look to see how the defendant is reacting. So I always instruct my clients to have no reaction to anything, because I want them to pay attention to the witnesses and to me, client. The other thing, again, with regard to that courtroom, I mean, the jurors are only like what 3 feet from the jury box.
Yeah,
and they're probably what about, I don't know, 8 feet, 9 feet from Karen Reed as she's sitting there. Then you miss it if you tried what was going on in the courtroom.
So like the other day when Jen was, we couldn't, if you weren't in court, you couldn't see the reactions because they had a display on the screen, but we could hear I think it was actually when they were showing the video again of the dash cam video of the scene, or maybe the 911 call. But again, Jen, you could hear her crying in the background as she's testifying, or listening to it. What would you want your client to do? And if you were Karen, you want her to sit there stoically, or do you want her to show some kind of emotional reaction to that?
I don't want the client to display fake emotion.
Mm-hmm.
So if it's a genuine emotion, I would certainly hope that the client in that kind of predicament would display it. And if
Right.
there is be any emotion, I would always instruct my client to look down at the desk, or down at her lap.
And she doesn't do that. She looks defiant. She has her head back. She's always got that defiant look. And a similar moment was earlier in the trial when Paul O'Keefe's wife, Erin, testified. And she was so sincerely talking about how much she valued the friendship that had developed between her and Karen. And then just going through the experience of that day, and she choked up. And I got to think the jury was looking to Karen to see, did she feel that same sense of friendship with Erin? Does she feel moved? Does she feel moved at all to see Erin choked up like that? And does she have a reaction to that? And if she doesn't, what does that mean?
Again, the thing about a jury, it's hard to know oftentimes what these 12, or here's, I think, what are there, 16, 18 people, jury so
16.
far?
Yeah.
They don't normally give you a lot. They're usually very, very stoic. Every now and then you'll have somebody who's kind of demonstrative. But you can also tell when they're listening and when they're done listening. And they start gazing out the windows. They look down at their feet. They yawn. They let you know that they're sick and tired of listening to something.
Big question that I have. This is probably a tough one, but hopefully you've been asked it before. Now, when I grew up, I used to read Alan Dershowitz's books. And I never really had any intention of becoming a lawyer, but I did just enjoy his books. And he was an advocate. He made me understand the importance of everybody's entitled to a vigorous defense. But what are the boundaries here? Not only legal, but what are the ethical boundaries here? So I think, for instance, of David Yannetti taking a 20-year-old kid like Allie McCabe, who's done nothing wrong and who's just testifying honestly in a trial, something that all she did was pick up Colin and bring him home. And he's up there making it seem like suggesting that those texts were manufactured and misreading intentionally. He knows that Lifetime 360 data shows that she went home, that she dropped Colin off and went home. But he's misreading it to the jury because that data was unconnected. Her device was unconnected to the Wi-Fi at home. So it's reaching out for a signal, and the cell tower was on top of the high school. David Yannetti knows that. But he knew he could exploit it. And here you go. You're smearing this girl where half her friends and neighbors now think that she's part of a cover-up. I don't know. What are the ethical boundaries here, Kevin?
Well, there's the ethical obligation to represent your client zealously.
Yeah.
So if I'm in a situation where I have something on a defendant, or I have something on a witness that I can use to discredit that witness, I have to do it. I don't really have a choice.
Yeah.
Now, am I going to misrepresent something? No, I'm not going to do that. Am I going to torture somebody who's telling the truth? No, I'm not going to do that. Am I going to work with a blogger and social media to crucify people who are going to be coming in to testify? No, I'm not going to do that. To be honest with you, and I've known David for 30 years. I don't know him that well. I see him in court here, there. I've always liked David Yannetti. I find what he's participating in here to be incomprehensible. I think what the defense, maybe at the direction of Karen Reed, I think what they've done together with the social media bloggers is it's disgraceful. It's disturbing. I don't know any defense attorneys who condone it.
Is it effective?
I think, if you want me to be honest, I think that the defense is hemorrhaging credibility. I think attacking these people who look like decent people, attacking them, I think is going to backfire. And then the other thing that I'm mystified by, if there is a conspiracy and John O'Keefe was killed in the house, that's what they're contending, then every single person has to be a participant in that conspiracy and that cover up. No, there could be nobody who is in the house or lives in the house that is not aware of the conspiracy and therefore a participant, either willingly or unwillingly. Yet they bring in Attorney Little to do two of the cross examinations, Mrs. Albert and then Albert Jr.
Yeah.
The cross examinations, I'm sure she worked very hard on these cross examinations. I'm sure she's a bright person. But Alan Jackson at least had to know that she's not a very good cross examiner. Those cross examinations, I mean, they again, I don't like to criticize her because I'm sure she worked very hard on it, but those cross examinations were awful. And you have to wonder why they would entrust two critical witnesses, two alleged conspirators, to someone who did not have the courtroom skills to expose them or unmask them as the conspirators. Why would you give those two critical witnesses a walk? Why would you bring her in and let these people just sort of slide off the witness stand unscathed? I don't understand what they're doing.
Do you think that was the plan all along, or were they going to the bullpen, adjusting to what they were seeing in the jury's eyes and their reactions?
Again, it's always hard to read what the jurors are thinking. Some of them will give you something, but most of them give you nothing. So I don't know that was a real consideration. I'm guessing that they divided up the tasks. I'm guessing that Yannetti did not know that Little was not a very talented cross-examiner. And, it was maybe too late once the cross-examinations began. And maybe he realized what a mistake it's been to include her. But I also think it's a bad look for any defendant to have three attorneys, even two attorneys. I want the jury to perceive me and my client as the underdogs surrounded by prosecutors and law enforcement.
Oh, that's a great point. Yeah.
I don't want my legal team to be so big that the prosecutor looks like the underdog.
Yeah, that's a great point. I never thought about that. And obviously you want to build that connection, that almost like a bond between you and the jurors, where they expect to see you every day and they trust you. But that's harder to do if you're getting three different people doing the crosses, right?
Three different people doing the crosses. Like, so when Little gets up to do her cross-examination of Mrs. McCabe, nobody's heard a peep out of her. None of the jurors have heard a peep out of her before then.
Yeah.
And she's got to have credibility, because when you pose a question to a witness, especially someone like Mrs. McCabe, who you're accusing of being involved in a conspiracy, some of the answers to those questions are going to be flat no's.
Yeah.
And then what you're hoping for as a cross-examiner is that if you built up your credibility with the jurors, they'll believe the real answer was yes. Even though the judge will instruct them to do the opposite, your hope is that they'll believe you, the questioner, the cross-examiner, over the witness. And if you have no credibility built up with the jurors, then that's not a realistic possibility.
Someone had asked me earlier to ask you, is there a way for a defense team, if you've lost credibility, to win it back? How hard is that to do?
I think it's impossible.
Impossible.
Wow. I think it's absolutely impossible. It's something that's so precious that you have to build brick by brick, and you can mess that up so easily, because again, everybody understands that you're a hired gun. So you have to protect that credibility with your life. You can't be seen doing crazy things in the courtroom and raising your voice and being all demonstrative and asking inane questions and harass witnesses. So, like, there was some witness, I forget who it was, that Yannetti was cross-examining, and the witness sort of padded the answer with a couple of extra facts.
Yeah.
And Eddie just harshly went at the witness. I didn't ask you that. You decided to add that information on your own. Blah 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 blah. I think that's a big turnoff. The better way to handle something like that is, and I've done this. You say to the witness, so you think it was important for the jury to know A, B, and C in addition to what I asked you. Is that correct? I say to the witness, okay, tell the jury that.
Okay.
Now you answered just my question. Would you do that for me? I mean, every good cross-examiner I've ever seen is also very conversational.
Right.
The
Right.
question might be brutal, but the tone is always conversational, unless maybe it's a detective and somebody who's really giving you a lot of pushback. Then
Right.
you
Right.
step it up a little bit. But for the most part, if you want the jurors to listen to you, it's got to be conversational.
Especially if the people that are the witnesses are coming across as just regular everyday people, such as the paramedics, the firefighters, the police, and all the witnesses that were in the house have come across at this point as just regular people,
It would be one thing if they're cross-examining members of organized crime,
Right.
People with criminal records. So I don't quite understand what they're doing here, and I've talked to other attorneys about it, and my opinion is shared by other people I respect.
How do most of the attorneys that you're talking to feel about this case? Are they buying into the conspiracy? There were attorneys on YouTube, plenty of them, that are buying into the conspiracy here.
None of my friends are buying into it. I've only talked to my friends, so I don't.
Yeah.
I don't know what the other gentlemen are saying, but I think people who practice in this area, I don't know anybody who believes in this defense. Everybody I know seems to think it's kind of absurd.
Yeah. Right. Interesting. That's I feel good hearing that, because you wonder too, like, are jurors vulnerable to some of the other things that regular human beings are, in terms of being susceptible to falling for conspiracy theories, or not being able to think critically when it comes to weighing evidence, or taking a superficial weighing of the evidence? Is that something? I like to think that that's something that's somewhat rare in lawyers, or what do you think?
Let me say this. I think, again, it's hard to know whatever a jury is considers important. One of the challenges for the prosecution here is that what we appear to have in Karen Reed is a complete psychopath who after running over her boyfriend, uh, constructed her own alibi, apparently deleted ring videos, brought individuals, like Jennifer McCabe, to the scene as alibi witnesses. I mean, to do this, she has to be completely devoid of any conscience. I mean, she has to be a complete psychopath. So 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 the jury's got to. They don't necessarily have to buy all of that, but they have to buy the basic premise that she orchestrated her own alibi, which for most people is unthinkable. And she looks like other than when she's acting up. I mean, she looks like a professional level person. She had a professional level job. She, she comes across in a nice manner. So are they really going to conclude that she's crazy enough to behave in this manner? And of course, the other alternative is, 10, 20, 50 people involved in a conspiracy when there doesn't seem to be any reason for it.
Right. What did you think about all the screaming? Does that possibly, like, she was, so we're going to hear from Denise that she was screaming in the house that morning and that woke her up. Then she's screaming, we've already heard, when she called Jen. We're going to hear the same thing from Kerry Roberts. We've already heard the 911 audio, and she's screaming in that too. Was that part of an act, or was there some kind of legitimate psychotic breakdown going down here?
It's hard to know. I mean, if she had retained me, one of the first things I would have done is had her evaluated,
Mm-hmm.
because I would want to know whether or not she was actually criminally responsible. I mean,
Yeah.
some of the statements that Jennifer McCabe testified to, for example, was I having my period?
Right.
I'm asked if am I having my period, would suggest that she was not actually possibly not responsible for her actions because of her psychological state. So I would have
Yeah.
had it evaluated.
Right.
And
Yeah, I
then
was. Yeah, go ahead. I'm sorry.
based on the report that I got from the psychologist.
Mhm. I was just happened to be reading on a something separate from this case. This were diaries from World War II. People that soldiers that fought in extremely shell shock situations on the Pacific Front. And one of the things that would come up that was common for people that were shell shocked, and sometimes these were people that had, for weeks or even months, had been some of the better survivors. But eventually you have this breakdown. And one of the common things that happens is they start screaming uncontrollably. And I just seeing that thinking, was there some kind of a breakdown here? But, and
That,
again,
yeah, based on that you're making a very good point. But again, as a defense attorney, what you want to do with when you have a client in that kind of condition is you also want to spend a lot of time with her.
yeah,
And you want to ask her a lot of questions, and then you want to evaluate how she's answering you, so that
right,
you can get a sense as to whether or not she's okay.
right,
Other thing is, with regard to speaking with a client and asking questions, it's obvious to me that at least early on, and maybe much later, that Yannetti believes that his client is actually innocent.
hmm
You got to spend a lot of time with your client, and you got to earn your client's trust. And you got to get that client to open up to you and tell you the truth, so that you don't make mistakes.
right.
Can't I can't make mistakes early in a case. I can't do it. I don't want to make any mistakes. I don't want to make I don't want to do anything that I'm not going to be able to correct later on. And I certainly don't want to find out the truth at the trial. I don't want to find out the truth then. I'm not
hmm
I don't tell my clients, if you tell me you're guilty, though, we're just going to fold up the tent and go home.
Right,
There may be ways to defend the client.
right, right.
I don't want to make mistakes that end up making the client's situation worse rather than better.
Because you were taken by surprise because she didn't tell you everything.
Correct. And so then when you think about what Alan Jackson and David Yannetti have done by exposing her to in media interviews,
I was just going to ask you that next. You read my mind. Go ahead.
that was malpractice.
Yeah.
That was malpractice. Again, let's say, for the sake of argument, that she conducted herself perfectly in any of these interviews, right? And yeah, maybe these interviews are being played on national TV, and maybe the jurors are being exposed to it. Okay, that's all possible. But at the trial, it's really up to the prosecutor as to whether or not he considers them inculpatory and therefore worth introducing. Defense is not going to be able to get that in.
Yeah.
Those interviews are not coming in over the objection of Lally. So, but she performed so poorly during those interviews that if I'm Lally, I absolutely have to play them.
I'm hearing that unfortunately most of them are not going to be entered because ABC didn't turn theirs over. So I'm not sure which ones they have. I know they will be using the one from Boston Magazine reporter Gretchen Voss. That's an audio. I'm not sure, there was the one she did on the court. They had a press conference on the courthouse steps for one of the hearings this summer. But then obviously the biggest one, if they could have got it in, was the 2020, I think it was 2020 interview or one of the other. It was ABC News. And I think they tried to get it and ABC fought it. So I don't, my thinking of this, trying to think it without, like, I'm not a lawyer, obviously, Kevin. So because it's edited, because ABC does, maybe let's say they do an hour or two's worth of footage, but then it's edited what they put in. If you don't get the whole footage because it's edited, is that why it's inadmissible?
The defense would argue, if the defense wanted to keep it out, they would argue that these statements are being taken out of context,
Right.
or X, Y, and Z, and they can't come in. And there is a doctrine of completeness. So
There you go.
they, and let me say one thing in defense of Judge Cannoni, who I know is catching a lot of grief from the Karen Reed supporters, and claims that her rulings are designed to sabotage the defense.
Mm-hmm.
Judge Cannoni has given them a wider berth to conduct their defense than I've ever seen. Maybe going all the way back to O.J. Simpson with Judge Ito.
Wow.
The latitude that she has allowed those defense attorneys, both in arguments and cross-examination. Cross-examination, she's given them more latitude by a factor of 10 than I think I've ever seen. So the idea that she's been trying to sabotage the defense is absolutely baseless. Other judges would have kept those attorneys on a very tight leash, very tight. It would have allowed them to go into a lot of the stuff with regard, what was the girl's name? Katie McLaughlin?
Yeah.
In a relationship with the Albert girl. What was the Albert girl's name? Caitlin?
Caitlin, yeah.
Okay. The vast majority of judges would not have permitted the defense to go into any of that.
Mm-hmm.
Because it's completely baseless. The idea that Katie McLaughlin lied about what she heard Karen Reed saying, when all the other witnesses say that heard the same thing, and that she was lying because she was on the track team or something with Caitlin 10 years ago, is absolutely absurd. The vast majority of judges would have shut that down immediately. Judge Cannoni has given the defense every opportunity to put forward their defense. Every opportunity.
Now, have you done cases yourself before with Judge Cannoni?
Yes.
So is this unusual for her? Is it because of the media spotlight? Why is she kind of going the extra mile in this case? I know she has a reputation of being someone that defense lawyers like anyways, but why is she going more in this case?
I have not done a trial. I've done hearings in front of Judge Cannoni. I've not done a trial in front of Judge Cannoni. Most judges are considered by the defense to be pro-prosecution.
Mm-hmm.
I think most defense attorneys would characterize Judge Cannoni as neutral to maybe slightly leaning in favor of the defense, but only slightly. I think that. But compared to everybody else, I mean, she's far better for the defense.
Right. I want to talk about the feds. This is just you must be blown away by what's going on with the feds here and their involvement in this case, the predication of it, the release of the grand jury minutes to be used here, obtaining the communications of everybody that was tangentially connected to the conspiracy theory, from Courtney Proctor to Julie Albert, who wasn't in the house. Let's talk about the feds. What are your thoughts on this?
I don't want to disclose sources, but I knew about the Fed involvement quite a bit before it became news to everybody else.
Mm-hmm.
I think it was unprecedented to have this investigation going on during the process. I mean, maybe not the trial, but certainly the prosecution of the murder case.
Mm-hmm.
I am stunned that the feds went to put in the time and the resources to try to uncover this, to unmask this conspiracy, because you would have thought that maybe after just a few witnesses, they would have said that this is ridiculous and they would have shut it down.
Yeah.
Why didn't they shut it down when they figured out that there's nothing here?
Right.
Why did they keep it going? In fact, why are they keeping it going now? Because technically they haven't ended the investigation. Technically, it's still open,
Yeah.
which is not atypical of a prosecutor. The prosecutor doesn't say, well, we're never going to charge your client with the case, the criminal conduct, blah, blah, blah. They just simply say that it's ongoing and you never hear from them again.
Right.
Maybe it may be one of that type of normal prosecutorial conduct, but for purposes when they know that there's no conspiracy and they know that the public perception is that there must be something because the feds are keeping the investigation open, for that reason alone, I don't understand why Josh Levy hasn't announced that the investigation found nothing and that the investigation has therefore been closed. That's what he should be doing.
What about the strange coordination between Josh Levy and the defense team?
Somebody's well connected.
Yeah, absolutely. I want to get to some questions that other people have, if you don't mind hanging with us for a little, Kev. One more thing on the feds. My understanding is that they can request these communications. They don't actually need subpoenas. So this is, and I could be wrong on this. This is just my understanding. So you please correct me if I am. But this is why they're able to get this for so many different people without having to make the case in a subpoena that has to be approved. So there's no accountability. Am I understanding that correctly?
I think what people don't realize is that for a lot of these social media companies, some of the seed, at least from what I understand, I may be incorrect about this, but it's my understanding that there was some seed money involved from the federal government,
Mm-hmm.
and that in order to also maintain the the liberty to conduct their companies the way they want, they have to provide law enforcement with back doors
Yeah,
and
that's the problem. Yeah.
cooperation. So it's very unnerving that the government has
Yeah.
that access.
And it's probably cheaper for these companies to just hand over the information than to try to get involved with their legal departments trying to fight it, right? So there's just, and like you said, they have just so many incentives to want to make the federal government happy, even potentially for corrupt reasons, But is this something that we need to address in terms of congressionally, to dial some of this back? It seems ridiculous, the amount of, just from a civil rights perspective, the amount of information that they can get without any kind of a true subpoena.
And there are so many requests from so many different prosecutors and so many different courts that you have to anticipate that there's probably almost no supervision over what they release.
Mm-hmm.
Because how could they devote the time necessary to examine each request?
Right.
So they probably just provide whatever law enforcement is asking for. No questions
And
asked.
And then there's no accountability where afterwards you can go and look and see, all right, what argument did you make for getting Caitlin Alberts or Julie Alberts or Courtney Proctor's messages? That's a part of accountability, right? You should be able to go back and find out what was the argument that you made for getting these. It can't just be, I think we want them. There has to be an actual argument, right? Or there should be.
I think it's going to vary based on each law enforcement, that the protocols that each one follows in requesting documents, and then each Facebook and Twitter, et cetera, are going to have their own policies. But what I would expect is that all you have to do is touch the bases.
Yeah.
You don't have to provide anything of any substance unless your request is somehow well outside of the normal request.
Right. Okay. All right. Let me get to some questions that other people have. Frank Perry says, I feel like the sidebars Yannetti and Jackson are asking the judge for help us. I'm reading it. That might have been mistyped, but she killed someone she loved. What do you think she will do to us? I don't know. That was kind of a hard one to follow, but.
With regard to the sidebars, I've never had a trial with 1/10 as many sidebars.
Okay.
it's extremely frustrating for the jurors in even just trying to watch it. It's I just never seen that many. I've never had that many sidebars.
How much is Judge Canoni responsible for that?
A judge is responsible for allowing the defendant or the defense counsel on behalf of the defendant to fully cross-examine a witness. And at the same time, the judge is also responsible for not letting defense counsel to unduly harass a witness. And at the same time, she's also got to maintain a schedule for the trial so that the trial doesn't drag out indefinitely and inconvenience the jurors unnecessarily. So she's got, and then the other thing is she also wants to protect the record from appeal.
Right.
She is, I'm guessing, I don't know what she's doing specifically, but my overall impression is that she wants to make sure that the defense has no appellate grounds whatsoever.
Right. Right. So she's, out of an abundance of caution, doesn't want to throw out any exhibits. A lot of these sidebars seem to involve exhibits that they're trying to get in, images of the text exchange or pictures, videos, things like that. Some of it seems technical, like it should have been properly ordered out. A lot of this stuff seems like maybe it's stuff that was not put into the evidentiary record before the trial.
I know from a final trial conference I had in front of Canoni last fall that she wanted all our exhibits agreed to and in order and pre-marked 2 weeks prior to the trial because she wanted that trial to be efficient. So I would imagine that she was trying to do the same thing with these attorneys and try to make sure that everything went as efficiently as possible.
And so what happens when a defense attorney wants to get in those exhibits during the trial?
There's an objection and then there's a sidebar, and I'm guessing that Judge Canoni is maybe a little bit surprised at some of the defense tactics. That's my guess. And I think that perhaps, like I mentioned earlier, I think Lally is probably overwhelmed. I don't think people appreciate how much work goes into something like this.
So someone asked Mrs. J, getting Yannetti to say, "I'm not getting the answer I want" during cross. How does Kevin think that played out to the jury? So is that just rubbing the jury the wrong way when he keeps hounding someone to get the answer that's specific that he wants? And a lot of times, to me, it looks like sophistry and legal tricks. A lot of the times, I don't know. What's your perception on that?
Again, I don't. It's more. For me, it's been more like the tone of sometimes Giannetti and sometimes Jackson. The tone is more confrontational than the discourse warrants. Where I think he could accomplish the same thing without alienating the jury, and you got to remember something. Canoni's listening to it, and if you're a defense attorney and you start ratcheting up the rhetoric and you start becoming harsher and harsher, the judge is going to come in and just yank the leash and cut you off. So that's another reason why you want to keep it as conversational as you can.
And this is from Marius, a friend who I've developed through this case. He's in Norway, so I can only imagine what time it is there. They're probably about 5 or 6 hours ahead. He says, will the fact that Karen herself orchestrated this in connection with her defense show malice when and if she's convicted? So I guess, would that play into, if she's convicted, will all this circus created play into the Judge Canoni's sentencing? I think that would be the question.
I would imagine that if Karen Reed is convicted, if she's convicted of second-degree murder, it's an automatic life sentence. So there's really no discretion for Judge Canoni to exercise. With regard to manslaughter with a motor vehicle, which has a 20-year maximum sentence, I expect Judge Canoni is going to give her 20 years. Because if the jury rejects this conspiracy, this frame job claim, Mahoney is going to have no, I'm guessing she's going to have no mercy.
Mhm.
And Karen's not going to be able to ask for any.
What do you think about, do you think that Karen was overcharged? So Joe Krowski has said this a lot on Court TV with me, that he thinks maybe Karen was overcharged here. Do you think there was any plea negotiations on either side? I mean, everything I've heard is that the prosecution was not open to any plea negotiations, but who knows? What do you think?
So let's say I had a manslaughter. Well, technically, my client was charged with second-degree murder, but it was really a manslaughter case.
Mm-hmm.
And it was obvious why the prosecution charged my client with murder, because murder carries, even second-degree murder, like I said, carries a life sentence. So there's
Mm-hmm.
no discretion for the judge. So the only game in town is approaching the prosecutor to get the prosecutor to null pros the murder charge, and then
Mm-hmm.
negotiate how many years on a manslaughter. So that gives the prosecutor an enormous leverage over you in negotiations, because you have nowhere to go. You can't go to the
Mm-hmm.
judge, nowhere to go. So it's either run the gauntlet and hope your client's not convicted of murder, or negotiate.
Mm-hmm.
That might have been the same thing that was at play here. I
Mm-hmm.
don't, or possibly the fact that, if it's true that Karen Reed went back to the scene and left him, in the minds of the prosecutors, that might have been enough to elevate this to murder.
Right. Will they be able to prove that? I mean, just even if they can show that she drove down that street, doesn't mean that she saw him there.
Well, when she was with Jennifer McCabe, and what was the other lady's name?
Kerry Roberts.
Ray Roberts.
Yeah.
And she leaps out of the vehicle and runs over to him as he's covered with at least some snow, and it's okay. And the conditions, and the other two can't see anything. Certainly, she was there before.
Right. And to me, I think a big thing is if she took some actions to cover her tracks, there are at least indirect indications that her GPS was turned off. So I think she may have turned it off before she left the house at 5 a.m. But we're going to see on that. I know that it had to be off, just looking at both the defense and the prosecution documents. The prosecution says that we were able to trace her going in the direction of 34 Fairview based on her phone activity. What they didn't say was we followed her GPS and it shows that's where she went. And the defense says that that's a lie, that they didn't fully establish that. But again, if the defense had the GPS, they would say, no, we looked at her GPS and we know where she went. So no one seems to look at cite the GPS in that 5 a.m. trip. So to me, that confirms to me it was off, but I don't know, could it have been off for some strange reason for weeks or something like that? If they were able to see on the GPS, for instance, when she went home at 12:30, that means she would have had to have turned it off at some time. So that would be a consciousness of guilt kind of thing. That could be a reason why they don't want to give up on the second degree, right?
I'm not aware of all the evidence that they possess, so I'm not sure which was the defining element or fact that in their minds elevated this to a murder case.
Yeah.
But I would imagine the fact that she left him there to go ahead and construct this alibi, I'm guessing that played a role in their thinking.
Sunny Day asks, do you think Lally should have brought the medical examiner in sooner? Is the jury tiring of witness testimony? And so let's just expand on that question that she has to also, what do you think about the strategy of the order of the witnesses here and not present this? So we've been in this for 3 weeks now, and we still, or is it 2 weeks? 2 weeks, and we still have not seen any direct evidence implicating Karen. So is this how you would have done it?
I think for Lally, I think that the approach he's taking is as cumbersome and as lengthy as it is. I think this is probably the correct approach. I think this is what I would do if I were in his position. I don't have any criticism of him.
Yeah. Okay. Interesting. Yeah. Because to me, just as someone who is a writer, I would want to, use some of the narrative elements that go into writing. So in writing a screenplay or a novel, you want to hook the audience in the beginning and then just kind of go through you have a certain rhythm to the way things are brought in, and you just even if you're thinking you're telling a ghost story as a kid, you don't want to just you have the hook, but then you're not going to just go 20 minutes of detail and then jump to something exciting. You got to periodically, every couple of minutes, throw something in there that holds their attention. Is there a way that you would do that in a jury? So you give some kind of hookish thing at the beginning, and then in every few days something else comes in, or is that just too seem like it's not a methodical way of doing it?
It's hard to develop a rhythm in introducing evidence through witness testimony at a trial. It's always disjointed. I know that people were questioning why they brought the DNA expert in, seemingly out of order. Well, those decisions are usually made weeks in advance.
Right.
On an estimate of when it would be appropriate to call her, and she buys her plane tickets, and and so she's here. You're gonna put her on as soon as possible. I don't have any fault with Lally. I think it would have been better for Lally, of course, as many people have noted, if he provided a more narrative opening statement, so that would have a better understanding of the timeline within which the murder and the cover-up took place. And when I say cover-up, I'm not talking about by the alleged conspirators. I'm talking about Karen Reed constructing her own alibi.
Looking through there's a Facebook group, a new group on the Karen Reed trial. I'm trying to see, people were excited about the show there, but it looks like they haven't had questions too many there. I promised that I would bring in any questions from them. So they were just happy to see this. Not a specific question. All right. I guess the last question that I would have, and this is maybe combines it's somewhat directed by your being an attorney, but just also as a citizen and as a human being. But as a citizen, the role of courage and trying. So when you published that article in September, did you know the backlash you were going to face? And do you have any idea the backlash you're going to get now from even just doing this show with me? What is the role of courage in citizenship and trying to stand up to an angry mob?
Well, I think, Kevin, you'd be in a better position to answer that question than I would. You've taken an enormous amount of abuse, and you've always stood tall. You've never backed down. You've conducted yourself with complete integrity. I have done maybe 0.1% of what you've done.
But you're one of the few lawyers coming out now in Mass. You may be the only one in Massachusetts, you and Joe Krowski. So are you worried about the recriminations? What are your thoughts on, I don't know. It's to me, it's like, it's a problem because I don't know how you stand, my way of looking at this over the last year has been when you stand up to a mob, you just try to show people a better way of thinking and hope that, I think most people are decent human beings, and hope that people will start to follow evidence more carefully and tune out people that are intimidating witnesses. But we're not seeing that happening at all. Their audiences are growing. So I don't know.
But you were kind enough to invite me on your show. You asked me some questions, and I tried as honestly as I could to answer them.
Mm.
I'm going to get crucified on social media for answering those questions, and so be it.
Yeah. I guess that's part of being a defense attorney anyways, because often you'll have to represent a client that is unpopular. And so you got to have a pretty thick skin, right?
Getting demolished by judges in the trial session will give you a rhino-like skin. It's like they can write whatever they want about me. They can say whatever they want. It's kind of irrelevant.
Excellent. That's good to hear. Well, let's finish up with one question on this. Tell us a story from your trial experience. It can be relevant to this case or not. Just something interesting. Looking back over it, maybe an interesting client that you've had, or a moment that was a crossroads point for you, or anything you might have like that.
There have been a few. The one that I probably gotten the most notoriety for is Christina Martin, the so-called Jello murderer.
Oh, I
And
remember that case. Yeah.
so she was convicted in the 90s. I don't remember all the dates. I think it was like the early 90s. She was convicted of first-degree murder.
Yeah.
Allegedly spiked her boyfriend's Jello with a lethal dose of LSD.
Yeah.
And she had a trial attorney who didn't really do a good job. And I was assigned to represent her in appeal. I was brand new. I hadn't even been a lawyer that long. And I had contacted the DA's office, and apparently by accident, they gave me some documents that they had not disclosed to prior counsel. And then that was like the thread, and I just kept pulling on it. And I got a good expert, Dr. Brian Pape, a phenomenal toxicologist, and we worked together on this case together with my friend Joan McGraw, and we uncovered an actual conspiracy where they knew that the evidence that they were introducing at trial was nonsense because they had run their own toxicology tests on the victim, and those were the best toxicology tests known at that time. That was the gas chromatography mass spectrometer.
Yeah.
That was considered infallible, and it found no LSD in any tissue samples. And if you want to, the funny part about it is they were doing what we would regard as screening tests. So the immunoassay tests, and they were showing massive amounts of LSD.
Yeah.
And they couldn't reconcile the two results. So they actually went and got a bottle of the embalming fluid from the funeral home, tested it, and that showed identical levels of LSD. So they knew absolutely the immunoassay testing was pure nonsense. And they introduced it at trial anyway. So the medical examiner's office was in on it. The DA's office was in on it. The police were in on it. Everybody knew that they were withholding that evidence except the trial attorney representing Miss Martin. And that's how I got it tossed. That's how I got her conviction overturned.
So what was the motive?
What
was the motivation by the corruption there? Was this just a rush to judgment where they initially were so sure that she had done this and the evidence was airtight that then after that they were down that path far enough that
rumors had circulated that my client had been poisoning her boyfriend at the behest of her daughter.
Mm-hmm.
And one of the young people that were hanging around with my client's daughter, her father was actually a state trooper. And so she divulged it to him, and then they exhumed the body, et cetera, and they concluded definitely that my client had committed murder. They were absolutely convinced. So when these kinds of results come out, the GC mass spec, they'll engage in whatever. Sometimes some of them will engage in whatever gymnastics they have to, intellectual gymnastics, to justify withholding that evidence from the defense. And that's what I think they did here. I think they decided that she was guilty and they didn't want to give her the key to the jail cell.
And I have one more question. Sorry, this came in and she was upset that I missed it. I didn't see it. This is from Cynthia, and I apologize that I didn't see it, Cynthia. I just accidentally skipped over it. I'm trying to balance between looking at the camera and looking at this monitor, which is my first time doing this. She said, thanks for the coverage. An uninvolved attorney was invited to sit with the Reed family to podcast juror demographic info and defense strategy to the public. The defense let so this is the DUI guy. This guy is an attorney. I'm not sure where he's based out of. He sits with the Karen Reed family in court, and he's known as the DUI guy. I guess he specializes in DUIs. So aren't these ethics violations is the question. So to have this attorney who is not acting as an attorney here, sitting with the Reed family and doing podcast juror demographic info and defense strategy to the public.
I don't have I don't have any reason to believe that discussing defense strategy. I don't see anything wrong with that. I mean, that's what we've been doing here this evening. As far as revealing jury graphics, I don't think that's a good idea. I think that's something that is very likely to run to be someone's going to tell Judge Cannoni, and she's probably going to do something about it.
So the fact that she's working with the defense team, or at least with Karen, anyways. Yeah, I would think so. And it also just going into the juror demographics. What did you think of Yanetti's trying to smear Matt McCabe as a racist because he referred to the Asian house? I don't know if you caught that part of it, but
I did. I don't think, me personally, I mean, look, I'm sure if Mr. Yannetti watched a trial of mine, he wouldn't agree with everything I did.
yeah,
But
yeah.
really see how that furthers his task here of demonstrating that there's a conspiracy.
Mm-hmm. So I think the same thing. I think a jury is going to look at that, and I know nothing about this, but just as a human being, thinking a juror might, even Asians on the jury, would be kind of resentful of that and say, your case is that weak that you have to try a cheap trick like that, even when it's so far as to criticize Matt McCabe because he didn't find out the names of the people that live in that house, and that's not even his neighborhood. That's a house that's near someone that he's friends with. So I just thought that was, if the jury is going to perceive a defense lawyer as trying desperate tactics like that, doesn't that go back to what you were talking about, the credibility problem?
Yes. The difficult task as you're preparing for any trial is to separate the good ideas from the bad ideas.
Yeah.
Plenty of ideas.
Yeah. Okay. All right. Well, thanks, Kevin. I very much appreciate it. I don't know, is there anything else that you wanted to get into, or?
No, thank you, Kevin.
Okay. Well, you did great. I very much appreciate it. We don't have the benefit of this kind of legal advice usually, so it's very helpful to a lot of people that are watching this.
Well, thank you for having me on. It's been my pleasure. Thank you, Kevin.
Hopefully you will come back again, Kev.
Okay.
All
Take
right.
care.
Thanks, Kev. All right, guys. And again, I apologize for not, for the annoyance of having to look aside. Oh, all right. Sorry. I've got the camera here. This is a new setup for me. I've got to get some kind of a monitor in front of this camera because this drove me crazy. So I could not help looking at Kevin, because over here is where the monitor is. And it's just the natural tendency to want to look at the other human being. So I kept looking at Kevin, but to you guys, it probably looks kind of shady, like I'm looking away. But just bear with it. I promise you I will fix this problem by tomorrow. I will come up with some kind of solution tomorrow. So tomorrow I will be doing a show with Kate. I'm not sure if it's going to be on my channel, on both channels. I don't know, but I'm really looking forward to that because we get to talk a little bit more at length about what's happened over the last 2 weeks. Nobody really has more information about this investigation than Kate, and every once in a while there are a few things that I have that she doesn't, that I can fill in the blanks or add to what she has. But this will be a really good conversation. So I will set up that event and look for the invite. For everybody that was here, thank you very much. Cynthia, thank Tom Fleming for pointing out your question because I didn't see it. It just, again, part of this problem of going back and forth to the other monitor. But for everyone else that was here, and I appreciated the question, it was a good question. This DUI guy really seems to have strangely come into prominence. You'll see, again, you see me looking away because the keyboard is over here in front of me, but that screen is broken, so I'm looking at the big monitor to read everybody's questions. Good to see everybody here. Angela, Kathy, Psych Nurse. Good to see all the regulars, because the regulars, Granny Juju, they would make it really. Without the regulars, it's definitely not really worth it because we're not going to ever have those audiences like the grifters get. So what we really appreciate is having the core audience that just is intelligent and asking questions. And that's, Yeah, I was. It was tough not to look at him, Barb. It was definitely. I find myself looking at him, and then I'd say, "Oh, look at the camera." People that probably do professional video work that are used to looking at a camera lens and pretending that's a person. I am not used to that. I am clearly not a professional. So I'm getting better at things, but I'm not a professional. I'm still just an amateur YouTuber doing the best I can. But I'm going to end the stream here, and we'll be back tomorrow. And if you're in the Rhode Island area, I don't even know the name of this radio station, but I'll be on tomorrow morning, the John DePietro show. Is it John? I think the first name is John. I understand this guy is really, really good. I haven't heard him because we don't get it. I'm north of Boston, so we don't get that station in. But it sounds like he'd be a good station to listen to. And again, signing off, everybody. See you tomorrow.